Hello, my name is Vitaly. I'm CEO and founder of realLaw AI. realLaw AI is an AI assistant of the UAE Laws. We have compiled all federal legislation, Emirates laws, and free zone regulations in one place and trained our AI to answer your questions with reference to specific articles. Simply ask and get an immediate answer. And this is our new series and monthly digest of UAE legislation updates. Every month, we break down what's new, what's changed, and who it affects: business owners, expats, lawyers, and accountants. May turned out to be less eventful than April, but the changes are very practical. Salaries via WPS, a new digital Know Your Customer platform, competition and merger control, E-Invoicing, of course we're talking about E-Invoicing, autonomous vehicles in Dubai, and a new law on archaeological sites. So let's start not with a general overview, but with something practical. A change that's already affecting businesses right now. In May, the Ministry of Human Resources published decision number 0341 on the wage protection system, WPS. The key point is simple. From 1st of June 2026, wages for the previous months must be paid no later than the first day of the following calendar month. Anything later is considered a delay. To comply with WPS, an employer must pay at least 85% of the total wage amount. Violations trigger a progressive response. First, it's going to be a notification, then restriction on new work permits, then fines, and ultimately labor proceedings. So what does it mean in real life? Companies registered with MOHRE, with WPS, need to urgently review their payroll processes and payment deadlines. And of course, one important note about laws. At the time of publishing this digest, the decision has been released by MOHRE, but has not yet appeared in the official gazette. This is very important because it's mentioned in the law itself. And of course, it's related to companies registered with WPS systems. So it's mainland companies, it's DMCC and JAVSA. Next, the digital KYC platform. The cabinet issued two decisions on this. The first, number 55, is the executive regulations for the KYC platform law. It applies to anyone who works with KYC data, collecting, storing, analyzing, or using it, as well as those who issue KYC reports. So how does it work? A company can request a KYC report on a client, but only with that client's consent. The request must include the client's details, the purpose of the report, and proof of consent. The company must verify that consent, comply with data provider agreements, and follow central bank rules. The client's rights are specifically protected. They can request their own KYC report and demand corrections if the data is wrong. So what goes into a KYC profile? For individuals, it's name in English and Arabic, Emirates ID, passport, visa, and so on. For a legal entity, a list is even broader. Its name, legal form, contact details, office addresses, and so on. The practical takeaway: companies in the financial sector and users of KYC reports need to understand in advance exactly what data they will be sending, receiving, and storing. Second decision, number 56, introduces a schedule of administrative fines for violations on the KYC platform. There are two fines, 50K and 100K. 50K applies for disclosing KYC data to third parties, not having a proper KYC platform, failing to notify the central bank, and so on. A fine of 100K dirhams applies for more serious violations. For example, issuing a report without verifying the client's consent, breaching agreements with providers, using data for purposes not permitted by law, or transferring a report or data outside the UAE. Before imposing a fine, the central bank may issue a written notice and allow up to 30 days for rectification. But rectification alone doesn't guarantee exemption from the fine. There is a 30-day window to appeal, and if no decision is reached within that time, the appeal is deemed rejected. Okay, next one. Competition law. The Cabinet passed decision number 59, the executive regulations for the new Competition Act. It comes into force 3 months after publication in the official gazettes. It will be 30th of July this year. One of the key sections covers the criteria for the dominant position. Importantly, dominance isn't assessed on market shares alone. The regulators also look at technological superiority, business model, financial resources, geographic concentrations, the ability to act independently of market pressure, barriers to entry and exit, and long-term or exclusive relationship with customers and suppliers. The document also clarifies that technological superiority or in sum, achieved through innovation, investment, or research, does not imply a dominant position. The problem arises when a company is able to influence the market in a way that restricts competition, limits market entry, or narrows consumer choice. Excessively low prices are also regulated. Prices below variable or marginal costs may be considered excessively low unless the company can demonstrate legitimate economic reasons. Prices below full average cost become problematic if there is evidence of anti-competitive intent, for example, to drive out a competitor or prevent them from entering the market. Also, it's very important that law regulates M&A deals. And by the way, there is also a formalized exemption process. It starts with a formal review of 10 working days, followed by substantive examination of 40 working days, with a possible extension of another 10. Until a decision is issued, the company must refrain from implementing the agreements in seeking an exemption for. One more decision in the competition block, number 96. It introduces a temporary exemption for agreements aimed at ensuring continuity of supply of essential goods and services in exceptional circumstances. This covers food supplies like rice, sugar, meat, fish, eggs, bread, and so on, as well as transport and logistics services. Companies may coordinate transportation, distribution, delivery schedules, storage, and so on, but only when necessary to prevent shortages. The key restriction: no price coordination whatsoever. Not direct, not indirect. So, next one. And it's our lovely E-Invoicing. Two major changes. The first affects businesses with a turnover more than 50 million dirhams. Under the current ministerial decision number 244, these companies were required to appoint a SP provider till 31st of July and implement the invoicing system from 1st of January 2027. New decision number 66 moves the first deadline, appointing an ISP, to 30th October, and the mandatory implementation date stays unchanged, 1st of January. The second change affects service providers themselves. Ministerial decision number 56 updates the accreditation rules. Valid people accreditation is now required, and so on. But now it's possible to count third-party experience and use third-party software and outsource some processes. But responsibility for compliance stays with the service provider. Okay, move on to new law about autonomous vehicles. Dubai Executive Council decision number 14 sets out the types of activities where autonomous vehicles may be used and the phases of their rollout. Autonomous vehicles can operate within existing transport schemes: passenger transport by bus and by car, vehicle hire and rental, and tourist transport. The RTA, Road Transport Authority, will separately define the conditions for each. Operations are divided into 3 phases. Phase 1, data and map verification. Phase 2, operation with a safety operator on board. And Phase 3, operation without a safety operator. In Phase 1, the operator must adapt the automated driving system to Dubai's transport environment, verify data on road traffic, weather regulations, emergency services, and traffic changes, and build continuously updated high-definition maps for approved operational zones. In Phase 2, the vehicle operates only with a safety operator present, until the RTA success criteria are met. Moving to phase 3 requires separate RTA approval. In phase 3, no license means no operation. The operator must comply with operational and safety standards, provide the RTA with a commitment to safe operation, and share operational data with the RTA and competent authorities on request. Private use are also tightly regulated. Owners cannot activate the automated driving system before phase 3 or without RTA approval. One final item. It's relevant for anyone involved in real estate or construction in Dubai. Dubai Law number 11 regulates archaeological sites and monuments across the Emirate, and it applies to all of Dubai, including maritime areas, mountainous zones, and free zones. The law's purpose is to identify, restore, and preserve archaeological sites. Owning a plot of land does not automatically give you ownership for any artifacts found on it. If something is discovered during works, you must stop immediately, notify the police or the competent authority within 24 hours, preserve the find, and hand it over to the authorized body. Without a permit, it's prohibited to conduct excavations, alter, damage, or demolish archaeological sites, remove artifacts from Dubai, trade in them, or use metal detectors or other such equipment. Okay, we are done here. This May brought practical changes across several areas: WPS, KYC Platform, E-Invoicing, competition, archaeological site, and autonomous vehicles. If you would like to go deeper on any of these documents, all the full texts of these legislations are available on realLaw AI. Subscribe so you don't miss the next monthly digest. Thank you and goodbye.